July 8th, 2014. It's 10 o'clock a.m. in the morning. It's my pleasure to call the order of the State of Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Mosley, will you please call the roll?
Robert Helms,
Present.
Wayne Hinkle,
Present.
David Neal,
Here.
W.T. Patterson,
Here.
Jane Gray Sowell,
Here.
Robert Starkey,
Here.
Anita Taylor. Mr. President, we have 6 out of 7 members here. We have a quorum.
Thank you, Ms. Mosley. Before we start, on behalf of the board, we'd like to express our condolences for the passing of your mother.
Thank you, I appreciate it.
We'll now adopt the agenda for the meeting.
Motion to adopt the agenda for today's meeting.
Second.
Have a motion from Mr. Hinkle, a second from David Neal. All in favor?
Aye.
Agenda is adopted. We will not have the minutes this meeting because of some various sicknesses and things, but we will have them at the next meeting. So we'll defer the minutes of the last May 6th meeting to the next meeting. Okay. We'll now have our legal report from our attorney, Ellery Richardson.
Sorry, I just caught a mosquito there. All right. Legal report. The first issue is for case number 2014-006011, 2014-006012, and 2014-006013. It's a funeral home and a funeral director's license and an embalmer's license. The complaint. The complainant's mother entered into a pre-need guarantee contract with respondent in 2006, which was funded by a life insurance policy. In 2012, complainant's mother bought an AARP policy naming complainant as the beneficiary. Respondents primarily communicated with the deceased's brother instead of complainant. Respondent told complainant that since the brother planned the funeral, he would be responsible for paying for it. Respondent Funeral Home embalmed the deceased and placed her in a casket following the 2006 contract agreement. When the complainant arrived at the visitation, Respondent Funeral Director told her that she was the beneficiary of the insurance policy, so she needed to assign the proceeds to the funeral home to fund the funeral services. Respondent Funeral Director notarized the document in violation of the Notary Public Statute, which states that one cannot notarize a document they are to obtain a pecuniary interest from. Respondent refused to give complainant a copy of the assignment until days after the funeral, when complainant came to the funeral home and asked again. Respondent Funeral Director required complainant to sign the assignment and a funeral purchase agreement for all the services he had already provided, but he did not give complainant a price list. She did not authorize any of the services already provided. Apparently, the deceased stopped paying her premiums, so the policies did not pay for the full cost of the services. Respondent sued complainant in civil court for the remainder of the contract. The court ruled in complainant's favor, finding her not liable for the contract balance. The judge also found that respondent did not provide a price list as required by law. Response. The respondent was unable to get a hold of the complainant until the visitation. Complainant never paid the outstanding balance for the funeral services, which was $5,803.92. Respondent filed a breach of contract claim in General Sessions Court. The court ruled in complainant's favor. While respondent disagrees, they are not appealing because of the expense. Respondent complied with all applicable law, and the court order is for a breach of contract claim and irrelevant to the board's decision and whether he provided a price list. Complainant signed the funeral purchase agreement, which includes the statement that she was shown the general price list and outer burial container price list before the provision of services. Then there are 4 closed complaints, and my recommendation is for the funeral home, a consent order with a $500 civil penalty and authorization for a hearing, and for the respondent funeral director and embalmer, a consent order for a $750 civil penalty and authorization for a hearing.
this outstanding balance for the funeral services ever paid?
It was not paid, no. I have not heard if, to my knowledge, no one has paid the order.
So was the brother's liability dismissed?
From my understanding, the respondent only tried to get the money out of the complainant and not the brother.
Accept the recommendation of council.
Have a motion from Jane Grace Howe to accept counsel. Do I have a second?
Second.
Second from Mr. Hinkle. All in favor?
Aye.
Any opposed? Motion carries.
Case is against respondent number 4, case number 2014008221. An inspector with the funeral board discovered that respondent's establishment license expired on January 31st, 2013, not 14 like I wrote, and had not been renewed. Respondent managers stated that they thought they had renewed it on January 31st, and they were just waiting on the renewal to come in the mail, but they apparently did not complete the process. Respondent renewed online while the inspector was still in the establishment. Respondent was unlicensed for 18 days, from February 1st until February 18th, and during this time, respondent handled 15 cases unlicensed. And they just apologize and say it was just an oversight. And my recommendation was a consent order with $250 civil penalty and authorization for a hearing for the 15 unlicensed cases.
Motion to accept council recommendation.
Second.
Have a motion from Mr. Hinkle, a second from Mr. Patterson. All in favor?
Aye.
Motion carries.
Next case is case 2014-010511. On December 30th, 2013, an inspector with the funeral board conducted an inspection of the respondent establishment. The inspector noted the following violations. The establishment did not have a current crematory license on file for the crematory it uses. The licensed respondent presented to the inspector was over 5.5 months expired. And the establishment did not have a copy of the latest crematory inspection report. It was faxed to the establishment while the inspector was present. Respondent admits that it did not have these documents available on file, but they are now current and posted in the main office. And there is one closed complaint. And my recommendation is a consent order with a $500 civil penalty and authorization for a hearing.
Motion to accept. Second.
Have a motion from David Neal, a second from Robert Helms. All in favor?
Aye.
Motion carries.
Next case is 2014-011071 against a funeral home or funeral establishment, and 2014-011012 against a respondent funeral director. On April 15th, 2014, an inspector with the funeral board conducted an inspection of the respondent establishment and noted the following violations. The funeral home's establishment license expired on January 31st and was not renewed until February 14th. During this time, the establishment and its manager and funeral director conducted 2 funeral services and arrangements. Response. On January 1st, the county changed the addresses for several thousand businesses and residents throughout the country. Respondent has had problems with receiving their mail. On February 14th, respondent realized that he had not received a renewal notice, discovered that his license was expired, and took immediate action to renew and change the address with the funeral board staff. Respondent has set internal policies in place to ensure that this does not happen again. There are no prior complaints, and my recommendation for respondent establishment, a consent order with a $250 civil penalty and authorization for a hearing, and respondent funeral director, a consent order with $250 civil penalty and authorization for a hearing.
Move to accept the recommendation of council.
Second.
Have a motion from Jane Gray Sow and a second from Wayne Hinkle. All in favor? Motion carries.
Next case is case number 2014-009901. On January 24th, an inspector with the funeral board conducted an inspection of the respondent establishment. The establishment did not have a copy of the following required documents: the crematory license for the crematory it uses, the latest crematory inspection report for that crematory, and a cremation authorization form for one decedent. Respondent had these documents faxed while the inspector was present. Respondent arranged for at least one cremation without the required inspection and license. Response. Respondent was not aware of the law requiring a copy of the crematory license and latest inspection report. They will comply going forward. Respondent later found the cremation authorization form. It had been mistakenly placed in another file. There are no prior complaints. My recommendation is a consent order with a $250 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Have a motion from Mr. Hinkle, a second from Mr. Helms. All in favor?
Aye.
Motion carries.
Next case is case number 2014-009731. On April 24th, an inspector with the funeral board conducted an inspection of the respondent establishment. The funeral director did not sign one cremation authorization form. Respondent apologizes for the oversight. While the funeral director filled out this form and signed all other required forms, he overlooked signing this one. There was one open complaint and one closed complaint. So my recommendation is a consent order with a $250 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Have a motion from Mr. Hinkle, second from Mr. Neal. All in favor?
Aye.
Motion carries.
Next case is case number 2014-009681. On March 11th, an inspector with the funeral board conducted an inspection of the respondent establishment. He found that 8 cremation authorization forms had not contained the signature of a licensed funeral director. Respondent is using a cremation form not approved by the board. Respondent does not list or offer an alternative container on their casket price list, in violation of the federal funeral rule. This violation is for their current price list and their most recent price list. Respondent has been in violation since October of 2013. Prices for outer burial containers are not the same as the prices listed on respondent's price list. In the response, respondent apologizes for the oversight of the lack of the signature. While the funeral directors filled out these forms and signed all the other required forms, he overlooked signing them. Respondent has since created an internal audit process. Unapproved cremation form. Respondent has since submitted a new form to the board staff for approval. Alternative container. Respondent states that this was due to a cut and paste error and has since been corrected. And he states that the price discrepancy for outer burial containers has since been corrected. There is one open complaint and 11 closed complaints against this respondent. My recommendation would be a consent order for $1,250 civil penalty and authorization for a hearing.
Move to approve the recommendation of council.
Second.
Have a motion from Ms. Sow, a second from Mr. Helms. All in favor?
Aye.
Motion carries.
Next cases are case number 2014-011091 against a funeral establishment, and for 2014-011092 against the funeral director's license. On March 10th, an inspector with the funeral board saw an advertisement for a funeral home he did not recognize. Since he was familiar with all the funeral homes in the area, he thought this unusual and traveled to the location in the ad. He saw a building with 2 workers building a fence on the south side. Before the inspector called the number listed in the yellow pages, the respondent funeral director arrived and told the inspector that he was in the process of opening a new funeral establishment. He stated that he had not applied for an establishment license yet because he was waiting on zoning approval. The inspector issued a citation for advertising as a funeral establishment before it was licensed. Respondent states that he placed the ad when he thought that the establishment would be ready. However, the zoning authority contacted him, stating that changes had been made to the site plan. This delayed the proper zoning by 4 months and also delayed his establishment application. Respondent attempted to cancel the Yellow Pages ad, but the company said it was too late to cancel and the books had already been printed. The phone number listed in the Yellow Pages had not yet been connected. Respondent apologizes for this unprofessional act. The establishment is not ready, so he has not applied for his license and he has not been operating as a funeral establishment. Respondent called the board staff in February to report this problem and to state that he didn't think the Yellow Pages would be out quite so early. There's no complaint history, so my recommendation for respondent establishment is a consent order with a $250 civil penalty and authorization for a hearing, and respondent funeral director a consent order with a $250 civil penalty and authorization for a hearing.
They have an establishment license now.
Not yet.
How do we have jurisdiction over someone that doesn't have a license?
It would just be unlicensed activity and offering to engage in unlicensed activity. Those are the violations.
False advertising.
Correct.
Motion to accept.
All of you know that when, if you're not careful with the Yellow Pages, if they get a credit card number or a check, they'll put it in there, and it's impossible.
Undo it.
You can't undo a Yellow Page ad. But the fact that they they put that in there, I'll give him credit for making that mistake. But the other mistake, and has he applied for establishment license?
Just recently applied.
Okay.
in
It
the
states
last
in
few
here
days.
that he had some zoning issues in his application. Can he answer the issues that this board requests?
Well, he didn't apply because of the zoning issues. He was getting that resolved before the application, is what he said. He just applied in the past couple days.
Okay. So
Is this a totally new facility and
It is.
it's not a restart, it's
No, it's a totally new facility. And the,
no pre-existing business connection or anything?
other than making the Yellow Page mistake, he was in the process of getting ready, but he hadn't applied. The only thing that showed that he was in business was the Yellow Page, correct?
Correct. He just placed that months before he'd even applied with our office.
Well, as a funeral director, you're recommending a $250 civil penalty against his license, and you're recommending a $250 civil penalty against an establishment that does not have established license, correct?
Correct. It would be for unlicensed activity and false advertising, for offering to engage in an activity that it's unlicensed for.
Would it not be, I'm not questioning your judgment on this, but would it not be appropriate for the full penalty to be imposed upon the funeral director since there is?
If the board would rather do that, we could change it to $250 civil penalty against just the funeral establishment. It's up to the board's discretion how they wish to proceed.
I'm gonna make a motion to amend that respondent number 11 and number 12 receive a letter of warning.
President, you have a motion already from Mr. Helms.
Oh, I'm sorry.
I'll rescind my motion.
Mr. Helms has rescinded his motion. We have a new motion from Mr. Hinkle. For a letter of warning. Do I have a second on that?
And that does not include any penalty. No penalty.
No, my recommendation is no penalty. He made a mistake with the yellow pages, okay? And you can't turn that yellow page ad off. This is an establishment that, you say was a prior, or is it a new establishment?
Brand new.
Brand new establishment. He had some issues with the zoning board that he didn't, I'm gonna give him the benefit, I'm saying give him the benefit of the doubt because the board had some problems with his site plan that he may not have been aware of, you know. That's the only reason that I'm saying is that I'm making a recommendation, 2 letters of warning.
Have a motion from Mr. Hinkle. Do we have a second? Have a second from Mr. Patterson. All in favor?
Aye.
Any opposed? Motion carries.
President, I have a question. Give me some guidance in as to what our inspectors should do, because this opens the door for people to go out and advertise their business before they become licensed. And historically, we've not allowed that. And, I mean, it puts the inspectors or field reps in a hard position to determine whether or not it's a zoning matter, whether or not they have a sign up at the business, and things of that nature. So historically, they have taken action anytime that there was evidence of operation of a funeral home. So I just would appreciate some guidance as to what, because obviously and it's entirely up to the board, but if that's what the board wants us to do, then, I mean, does this open the door for people to advertise funeral homes that are unlicensed then?
That was not the intent of my motion.
I think.
The letter of warning would still cite that he violated the law, but it would give him the benefit of the doubt of the mistake and the fact that he had no former complaints. So it would still be a violation going forward. It was just based on these facts, the board decided to give him leniency. That's how I would see that.
So do you want the inspectors then to continue doing as they've done in the past, and then if there's a questionable situation, then the board make the decision then as to?
That's
Is
how
that
I
the
would
best thing
recommend
to
it.
do?
I would
That
think
would
it'd be the board's place to interpret that, yes.
Okay,
Yeah.
so the inspectors just continue to do what they've done in the past?
I would
and then
think the
board
inspector
make
should
the-
do that, because
Okay.
each case is kind of like this. Each case is individual, and, you know, some people are just, you know, indirect, you know, no question about it. This, where, of course, Mr. Hinkle's been in the situation on, you know, permits denied and what have you because of his job. So I think he's more, can see the problems here more so than some of us probably. But I would think the board should continue to do the inspections just as they have.
I appreciate that. That was all I was looking for, some guidance as to what to do.
Continue.
All right, the next case, one of our litigating attorneys has been working on this case, and he is here to answer any questions you might have. This case is number 2013-014051. The complainant filed a complaint alleging that respondent embalmed her deceased spouse without her permission and against decedent's expressed wishes. Additionally, complainant states that when she contacted respondent to have the body moved to the funeral establishment of her choice, she was verbally abused by the respondent. On July 18, 2013, the board sent a letter notifying respondent of the complaint and requesting a response to the allegation within 14 days of receiving the letter. The board did not receive the respondent's response until October 9, 2013. On October 9, 2013, the board authorized a formal hearing with authority to settle by consent order for not less than $250 and the suspension of the establishment license for a period of not less than 3 months. one of the department's litigating attorneys spoke with the respondent by and through counsel and ascertained through the evidence provided that respondent had a reasonable belief that he was authorized to receive the decedent's body, and that verbal instructions given by the woman claiming to be a decedent's next of kin was carried out in good faith. Furthermore, we have sworn testimony from a witness, non-interested party, that corroborates respondent's claim that he never spoke directly to complainant and therefore could not have verbally abused her. Lastly, complainant and decedent were estranged and not cohabitating at the time of decedent's passing. However, decedent was cohabitating with the woman who initially contacted the respondent. Additionally, the department has attempted to contact the complainant on several occasions through various means to no avail. We have convincing information that complainant had been advised by another funeral establishment that she possibly has a civil suit against respondent and that filing a complaint with the board is the first step in the process. So our recommendation would be an amended consent order with a $1,000 fine for not responding to the complaint in the allotted 14-day window. And it should be noted that the respondent has agreed to the proposed modification by and through council upon board's approval.
Isn't $1,000 a little stiff for that? I mean, due to, the response that we have, where, sometimes you have to take things on blind faith. He thought the person that was living with had responsibility, and this other lady comes up, so.
The complainant is his wife.
Correct. Well, this had
Other
been
person
changed.
is a
Sorry.
girlfriend?
That was my understanding. Mr. Bellamy. This is Mr. Bellamy. He's the one who negotiated this case.
Generally, if you don't respond, we automatically give you a $250. This responded, but late, and then we find $1,000. Is there more to this than I'm
Well, the
looking at?
original consent order was for $250 and a 3-month suspension. So instead of the suspension, they had decided to change it to $1,000, but Mr. Bellamy can speak further.
Mr. Bellamy, if you don't care to sit at the table so there's a mic so we can pick you up on the video.
Chris Bellamy, Assistant General Counsel for the Board. Upon investigating this matter, that is correct. The $1,000 fine was offered as a settlement by the respondent. So at that point, I wasn't going to negotiate him down.
Okay.
And to answer your question, Commissioner, that is correct. The respondent, the woman that called and made the arrangements, she had been in a relationship and living with the deceased for about 20 years. They had a breakup, and then she came back in the picture, and the wife and the decedent were no longer together. So at the time, the decedent and the young lady that called to make the arrangements were living together.
What about the next of kin issue here concerning embalming and
Well, if
those
you,
kinds of things?
the report from the hospital listed the girlfriend as the next of kin. So by all intents and purposes, she had the authority to make the decision, funeral decision.
The funeral director interviewed her and asked if he'd ever been married. Status. What was the answer given that has to be placed on the death certificate?
That's when he found out that there was somebody else, at which point he immediately moved the body. Once he was contacted by the estranged wife, he immediately moved the body to the funeral home of her choice, and it was a different funeral establishment. So he corrected the error upon notification that he made a mistake.
And the department has, in lieu of the revocation of the, or suspension of the license for 3 months, as was in the original he or she is volunteering to pay $1,000 fine
Right.
in lieu of the license suspension.
Well, how the department views that is, based on the evidence, I don't see anything that he did wrong as far as receiving the body, embalming the body per the instructions. All that was made in good faith. The thing that he did wrong was not respond within the 14 days. So, I think the consent order, or excuse me, the complaint was sent out in July. He didn't respond until October. That's a fact. So he's willing to admit to that fact and pay a $1,000 penalty for that.
Motion to accept council's recommendation.
Second.
I have a motion from Mr. Hinkle, a second from Mr. Neal and Ms. Sal. All in favor?
Aye.
Any opposed? Motion carries.
Thank you, Commissioners.
It clears up the mud. Kind of think I knew the answer to the question when asked.
All right, there are a couple more represents. The next one is case number 2013-000751. This funeral home is no longer owned by the same owners or operated by the same managers the complaint was filed against. Therefore, I recommend the complaint against the establishment be closed.
License for the original funeral home, have they been turned in or
Funeral home's been sold, Mr. Hinkle.
been sold?
It's
Okay.
been sold
Motion to
to another
accept council's
party.
recommendation.
Second.
Have a motion from Mr. Hinkle, second from Mr. Helms. All in favor?
Aye.
Any opposed? Motion carries.
All right, the next case is case number 2009-002681. Complainant alleged that the funeral home took $118 of insurance premiums that should have been sent to the insurance company. The funeral home terminated the employee responsible. The manager the complaint was opened against no longer works for the funeral home, and the current manager stated that he worked to remedy the wrong. So my recommendation would be to close this case with a letter of warning.
Motion to accept council's recommendation.
Second.
Have a motion from Mr. Hinkle, a second from Mr. Patterson. All in favor?
Aye.
Any opposed? Motion carries.
All right, this next couple of cases you've seen once or twice before. It's been pulled because of additional information. It's been pulled into investigations, and so now it's back. So this is case number 2013-013641, 2013-013642, 2013-013643, 2013-013644, and 2013-013645. On July 11th, 2013, the board received a complaint supported by 6 various affidavits or depositions of former employees, encompassing the 5 respondents referenced. The complaint has been subject to in-depth investigation and additional affidavits. Respondent funeral director instructed employees to not order markers or monuments. The respondents determined which monuments to place based on how often the family members complained. If the family did not complain enough, the monument or marker was not ordered, and all the money was kept in the establishment. At one time, a large number of bronze vases were stolen, and respondent funeral director did not replace them. The employee was instructed to remove vases from monuments that did not appear to be visited often, and to place those vases on the monuments where family members were complaining about missing vases. The sheriff's office recovered some vases and approached the respondent. The employee stated that he was positive they were not the same vases because of markers on the vases, but the respondent funeral director took the vases anyway, telling the sheriff that they were his stolen ones. Following a fire on April 17, 2012, respondent funeral director continued to accept dead human bodies for cremation services with knowledge that the establishment lacked the proper refrigeration facilities. And respondents deny these allegations and state that they sent bodies to other crematories. Respondent funeral director stacked bodies containing putrefying remains in an unrefrigerated back room at the establishment of respondent number 20. Since Respondent 20 only had a refrigerator large enough for 3 bodies, Respondent Funeral Director had an employee move stacks of boxes containing dead human bodies into a small building where they remained for days, resulting in an overpowering stench of decomposing bodies. Respondents admit that Respondent 20 had a refrigeration unit that only held 3 bodies, and they acknowledge that bodies sometimes smell. But respondents deny that any boxes of human bodies had ever been placed in a small building for any reason other than for a period when a large cooler and adjacent structure was used. Excuse me. On occasion, Respondent Funeral Director had employees place numerous boxes containing dead human bodies in stacks in a van to hide them from funeral board inspectors. Respondents admit that they have a van, but deny that they have ever used it to deceive state employees. Respondent Funeral Director moved dead human bodies around on what employees called a church truck. An employee witnessed as many as 6 or 7 boxes with stacked, smoldering bodies. Respondents deny stacking bodies 6 or 7 boxes tall, as the weight from the bodies would cause the boxes to collapse, and that would require heavy machinery. Additionally, respondent states that the inspections are unannounced, and so they would not have had time to move bodies around. Respondent Funeral Director routinely substituted cheaper merchandise for merchandise specified in pre-need contracts and retained the difference in prices for his personal benefit. Respondents deny this allegation and argue that if respondents provided the customer merchandise which was different than the merchandise specified in the pre-need contract, respondents so advised the customer, obtained their consent, and provided like kind and quality merchandise. They state that they did not engage in any practice designed to defraud customers. Respondents specifically assert that if the family of the deceased chooses a less expensive casket, the family may choose to be given a refund for the difference in amount or a credit to use towards other merchandise. To carry out this scheme, Respondent Funeral Director painted cheaper vaults and placed liners in them to create the appearance of the more expensive and requested brand vaults. Respondents deny this. Additionally, Respondent Funeral Director ordered cheaper poplar caskets, painted them with a cherry stain, and then sold them as though they were more expensive cherry wood models without revealing the difference in quality or price to the customers. Respondents deny that they ever painted or stained caskets for any reason. They are aware that some casket companies make caskets out of poplar wood, which is stained a cherry color by the manufacturer. Otherwise, when a casket is displayed, a description of the material from which a casket is made is attached in accordance with the law. Respondent Funeral Director converted customers' refunds from pre-need contracts for his personal benefit rather than refund the customer's money. When the funds invested under a pre-need contract yield a return greater than the fair market value of the items purchased and services to be rendered under the contract, Respondent Funeral Director simply increased the cost in order to keep all of the money. Respondents deny this. Respondents cheated customers by using names for caskets that were ordinarily employed by Batesville, such as Primrose. Respondents deny the allegations that they have ever cheated their customers in any way. Respondents admit that they name and rename caskets as is customary in the industry. However, respondents specifically deny that they engage in any business practices intended to deceive their customers. Respondent Funeral Director purchased inferior caskets, many of which were damaged and some of which had holes in the welds. Respondents had a body shop they used to repair these damages, and cheaper caskets were substituted for more expensive models purchased by families. Respondents admit that they made a one-time purchase of caskets from the seller mentioned, but deny any of the caskets were damaged or that they substituted these caskets for more expensive models. On one occasion, Respondent Funeral Director accepted a restored 1951 Ford motor vehicle with an estimated value of between $20,000 and $25,000 as payment in kind from a husband and wife for their funerals. No funds were placed in trust for these pre-need funerals, and the purported price of the 2 funerals was far less than the estimated value of the motor vehicle. Respondents admit that the funeral director accepted a restored 1951 Ford motor vehicle, but never had the car appraised and therefore neither admit nor deny the allegation as to the vehicle's value. Respondents aver that the husband and wife were the grandparents of Respondent Funeral Director's wife, who were concerned about paying for the funeral and asked Respondent if he would take the car as payment. Also, the grandparents asked that the car be used in their funerals, and Respondent agreed to take the car in exchange for 2 funerals as a favor to his family. Respondent took possession of the car and executed a sworn statement stating that the couple's funerals were then paid in full. Funds could not have been placed in trust because respondent never sold the car, as he was saving it to use in the funerals, and no funds exchanged hands. Respondents deny the charge of the funerals being written off as bad debt, and respondent stored the car for years and has since returned the car to the family. Complainant responds to respondent's attempt to explain the situation away by providing an affidavit from Mr. Burns, the husband in this transaction. Mr. Burns and his wife were the grandparents of respondent's ex-wife. At the time of the transaction, respondent and their granddaughter were already divorced. He gives a letter from the respondents indicating that the prepaid funerals are valued at $8,500 each and that any inflation increase would be absorbed by the respondents. Respondent told him that he was taking the car in trade for the funerals. Respondent then put the title in his name. The statement of funeral goods selected show amount of $9,562.62. Grandfather never received any explanation as to why this amount is over $1,000 higher than the original agreed upon amount. He claims never to have gone over this document beforehand, and he never visually selected any merchandise with respondents. Instead, the document was sent to him with a letter memorializing the transaction. Grandfather has never seen any sort of pre-need funeral contract. He did not give any payment other than the car, and he has no documents showing any investment of money to pay for these two funerals. Respondent returned the car after a news story aired, and the gentleman believes the 1951 Ford is worth considerably more than $17,000, which is the sum of the two contracts. On multiple occasions, respondent funeral director accepted checks as payment for funerals, endorsed the checks, and then wrote off the amounts as bad debts without placing the funds in a trust so that they would be available when the need for the funds arose. Respondents deny this. Respondent funeral director instructed employees to place cash payments for services in an envelope and place that envelope in that respondent's desk drawer. Respondents deny this. Respondent funeral director pocketed funds for funerals without placing them in the establishment account, marking them off as bad debt. Respondents deny this. Respondent funeral director sent fraudulent documents to Forethought via interstate wire transfer to deceive customers and deprive families of the refunds. Respondents deny this and further assert that they sold merchandise for the price listed in their general price list, which is regulated by the federal disclosure requirements. When a competing funeral home generously provided additional space to the respondents for embalming purposes after the April 17th fire, an assistant of respondent funeral director solicited business from a grieving family on the premises of the generous funeral home on the same day that they brought their deceased loved one to that establishment for services. Respondents deny that any of their employees solicited businesses from a grieving family on the premises of another establishment. They state that respondent funeral home manager received a call from a price shopper who inquired about funeral services and prices. As requested, the manager met the family in the respondent funeral home, where they discovered that the family had also contacted the competing funeral establishment. Respondents deny solicitation of any kind took place. Respondent funeral director knowingly submitted falsified apprenticeship forms to the state of Tennessee on behalf of the respondent's daughter. These falsified documents included quarterly reports and records of time not actually spent with the daughter's sponsor. Respondents deny this and further state that the one alleging this worked primarily as an embalmer at the respondent establishments and waited on very few families during the time these allegations took place. The daughter of respondent funeral director worked primarily under the funeral director and the manager of the establishment rather than with the complainant. After respondent funeral director accused the complainant of violating a non-compete agreement, respondent funeral director instructed an employee to attend the May 8, 2013 burial services where complainant was to say a prayer, as previously expressly requested by the deceased. This agent took a photograph of the complainant just as the mourning family bowed their heads to pray and just before a family member was to read a passage. The family members witnessed this profoundly disrespectful conduct, and the decedent's family was very upset. Respondents admit that they filed suit against the main complainant in this case for violating a non-competition agreement. Respondents deny that they instructed an agent of respondent number 13 to attend the May 8th burial services and state that an employee always attends services that occur at the respondent's cemetery. And as you can see, there is a very long complaint history here. So my recommendation for Respondent number 16, funeral director, will be a consent order for the voluntary surrender of his license and authorization for a hearing. For the respondent number 17, embalmer, consent order for the voluntary surrender of his license and authorization for a hearing. And for respondent number 18, consent order with the $6,000 civil penalty, a 3-month license suspension, and authorization for a hearing. Respondent number 19, a consent order with a $6,000 civil penalty, 3-month license suspension, and authorization for a hearing. And respondent number 20, consent order with a $6,000 civil penalty, 3-month license suspension, and authorization for a hearing.
Motion to accept council's recommendation.
Chairman, on the advice of the director, I recuse myself from this case.
Ms. Al recuses herself from this. So noted. We have a motion from Mr. Hinkle, a second from Mr. Patterson. All in favor?
Aye.
Any opposed? Motion carries.
That is it, as my voice is finally finished.
Thank you very much, Ms. Richardson. All right, our next on our agenda is administrative matters. Mr. Robert Gribble, Executive Director.
First item is the licensee report, Mr. President, and that's a report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of May 6, 2014 through July 7, 2014. Those establishments and individuals are listed there for you. If you have any questions about any of those, I had to answer that.
Where are we?
No, just two new establishments, and then there's several individuals. Of course, the board actually approved the first one listed there, but because we issued the license, I made it part of the report, so you would several individuals that are listed. So,
Let me get back to it. Help me. I apologize. I don't know what happened. I apologize.
yes.
Oh, I've got it. I just,
So this is a 2-month period. Remember, we did not have a meeting in June. So this covers from our last board meeting, which was on May the 6th, up through yesterday. Yes, those are the ones that we've administratively reviewed and approved because they met all the requirements. You do have some individuals to come before you today and an establishment to come before you today that we reviewed but did not approve because we need to bring those to the board for the board's determination on those.
move to accept the recommendation of the director.
Second.
Have a motion from Ms. Sal, a second from Mr. Hinkle. All in favor?
Aye.
Motion carries.
Closed establishment report, 2 establishments reported closing since the last board meeting. S&S Chapel Services, 701 South Highland Avenue in Jackson, and Peebles, Fayette County Funeral Homes and Cremation Center, Piperton office located 3725 Highway 196 South, Suite C in Piperton. About a year or so ago, yes, they've not been licensed for too long, and that made the decision to close that one particular office. A disciplinary action report, those are are consent orders that were administratively accepted and approved by the executive director pursuant to board authority for the period of May the 1st, 2014 through June the 30th, 2014. Been sent to you by an email, and we just put them together in alphabetical order so that you would have those. Open complaint report. As of yesterday, we had 0 complaints open against apprentices, 7 complaints open against either funeral directors and/or embalmers, and 57 complaints open against establishments, for a total of 64 complaints. And in keeping with the board's tradition, we have some proposed meeting dates for 2015. Those all fall on the second Tuesday of the month, as in the past. We've been asked to get the board to approve those so that litigating attorneys can set appointments for the administrative law judges in case they have formal hearings for those dates, and so we can publish those dates. So those are simply go throughout the year on the second Tuesday of each month. They ask us specifically this time to get approval for the meeting dates, so I guess, Mr. President, if you could get a motion and a second for the
Right.
approval of the report, and then we'll do the meeting date separately. We should have listed that as a separate item on the agenda, but instead of putting it in with my report.
On, first is the administrative matters and the report.
Motion we accept.
Have a motion.
Second.
Okay, I have a motion from Mr. Neal, a second from Mr. Patterson. All in favor?
Aye.
Motion carries. Next will be set meeting dates for the second Tuesday of next year, just as it's been in the past.
Motion.
Motion from Mr. Hinkle,
Second.
second from Mr. Neal. All in favor?
Aye.
Motion carries. Thank
That
you.
concludes my part, Mr. President.
All right. I think the next would be approval of license applications. Individuals first.
Robert, if you would, please come up to either side there and have a seat where there's a microphone. Let the first gentleman introduce himself, and he's here as an applicant for a funeral director and embalmer, and the reason he's here before you today is for the board to examine TCA 62-5-317 and making a determination as to whether or not he meets the qualifications and requirements for licensure.
All right, first I'd like to give honor to Jesus Christ, the Executive Director, Mr. Gribble, to all the board members that are gathered here today, and any John Gupton alumni. My name is Robert Manise. I started this journey 4 years and 7 months ago in pursuit of obtaining my funeral director and embalmer's license. It's been a long journey. I've endured the rigorous gauntlet of John Gupton testing, which I do appreciate. I've also learned a lot of rules and regulations and respect for the funeral board, to which I plan to be a participant in this business for a long time. As I stated, I'm honored to be here, and I've experienced a lot of things, learned a lot of things about the funeral business, and I look forward to learning a lot of things, not only within the industry, but from licensed professionals that have been a part of the business for a long time, that will continue to enhance my learning ability and to make me the best funeral director and embalmer in the funeral service industry. So I thank you all for your consideration and me being a candidate to receive my funeral director and embalmer license today. Thank you.
The issue that brought you to this board today happened in 2004, and you attended the necessary classes. Motion to approve his application for his embalmer's license and his funeral.
Have a motion from Mr. Hinkle, a second from Mr. Patterson. All in favor?
Aye.
Any opposed? Motion carries. congratulations.
Thank you.
Thank you.
Thank you.
Do us a good job.
All right. Yes, sir.
Gary. Gary Leon Britt.
He stepped out.
Look for him.
Good on your scores.
What is this, that the test records are no longer available from Georgia?
That's a comment by the applicant. I would just ask him to say, I'm not sure what he means by that. Georgia did provide certification of his licensure for us.
They did. No question about that.
No question about him being licensed. I don't know what his scores were at the time.
Is this reciprocation?
Yes. The last two are both applications for funeral director and embalmer's licensed by reciprocity. Move on to Mr. Dole, Mr. President. Well,
Yes, let's go on and move on to Mr. Doyle.
you would just come up and have a seat. This applicant is before you today for the board to make a determination about TCA 62-5-317. Mr. Dole, go ahead and
Good morning,
made
members.
you one.
My name is Frederick Dold, and you'll see that a little different spelling on my first name. My mother said her first choice was Sue, and sometimes maybe I think it would be better if she would have named me Sue.
What's the origin?
Austrian.
Austria.
I've been licensed since 1996. Have 25 years' experience in the business. Back prior to going to Mortuary College, had a little problem sleeping in my vehicle and getting caught with that, but that's been over 23 years ago. Never received a ticket. Driver's license out of the state of North Carolina. I still sleep in my car, but I don't drink alcohol prior to. Bridges Funeral Home in Knoxville.
On occurrence.
Yes, sir.
Also been employed in Nevada?
Yes, ma'am.
Do you have a license?
I still have a license in Nevada. Yes, ma'am.
Have you had a continuous license for the past 5 years?
In Nevada, I have had
A
since
funeral director,
1996.
yeah. For the past 5 years, you have been duly licensed.
Yes, sir.
Okay.
I also have a license in Virginia, and that's when I actually reciprocated from. When I reciprocated from Nevada to Virginia, it took the lady about 6 months to get my license verification to Virginia. So this time around, I thought, you know what, I'll just reciprocate from Virginia, and hopefully I wouldn't have to wait the 6 months. The lady in Nevada takes care of herself, so very limited on her time. But I don't know what the confusion was when it reciprocated from Nevada. She said she had mailed it and faxed it many times, but Virginia kept stating to me they hadn't received it, so it was quite a lengthy process. So when I reciprocated to Tennessee, I decided I'll just reciprocate my Virginia license, which came right over.
You still currently
I still
also
currently-
have a license in Nevada?
Yes, ma'am.
And also the,
And from
Commonwealth.
Virginia. I have 2 licenses, yes, ma'am.
been any interruption or?
Motion to accept.
Second.
Have a motion from Mr. Neal, a second from Mr. Hinkle. All in favor?
President, I made that motion.
I
made that motion.
apologize.
Yeah.
Have a second
Motion.
motion, okay,
Second.
from Mr. Helm, second from Mr. Hinkle. All in favor?
Aye.
Motion carries. Congratulations.
Thank you very much.
Move on
Mr.
to the establishment next.
I guess so. Has Mr. Britt left, or?
We'll put him to the end of the meeting if that's okay, Mr. President.
That'd be fine, yes, sir.
The establishment you have before you today is an application from TLC Mortuary Services LLC at 125 Lyle Lane here in Nashville. And present are the principals of that limited liability company. If they would introduce yourselves for the record and whatever opening comments you want to make.
I'm Philip Odom. This is my wife Phyllis. I've been licensed since 1974 in Tennessee, double licensed. She's a graduate of John A. Gupton and since 95 with her double license. And we're asking for permission to put a removal and embalming service in on the Lyle Lane address.
On doing any cremations? Are you planning on doing any cremations?
No, sir.
Okay.
No
Just
cremation.
embalming and removal?
Exactly.
What kind of facility do you have? Or are you going to have a facility?
It's already in. It's been inspected.
We have 2 photographs of it that I'll start with Miss Sal because photographs just do not show up well on the iPads, and we apologize for that. We've got to try to figure out some other way to get those to you, so we just print them and bring them to you for the time being.
You will do embalming.
Yes, ma'am. We'll be doing embalming and removals for out-of-town funeral homes as well as funeral.
Cremation.
No cremations, no ma'am.
At the church or anything, or you just?
No, sir. No, it's strictly an embalming and removal service. There'll be no public come to that facility.
Occupancy slip, and also on your zoning letter, it doesn't address one thing that's normally addressed in the application when you file one of these, and that is the parking requirements for that building. And I noticed that the front, there's no parking stalls marked off or anything. And tell me again exactly what services you're gonna be providing there.
We'll provide, do removals for the funeral homes,
Okay?
either in Nashville or across the state, taken to our facility and embalmed and then delivered back to the funeral homes.
So there will be nobody there but your employees, no family members will
This is the
live.
employees.
I'm looking at the employees.
You're looking
okay?
at-
And
at
there's not
everybody.
gonna be anybody
No, sir.
coming there.
No, sir.
Have to have handicap parking or anything like
Of course, one of the requirements that normally we see in these, in this thing is that it meets the parking requirements based on the zoning use of it. Neither one of these letters address that, but,
The parking, curbs and parking signed off on it when I went through codes to get everything approved.
yeah, okay. Did they give you a letter when?
No, so the only two letters that I would have had was for the zoning
submitted.
on it and for, water and sewer.
But it wouldn't be in trouble to get a copy from them for the parking and stuff?
I don't know if they issue letters. I mean, that's.
Well, normally when you, I'm a retired building official
Yeah.
and city planner. So I mean, that's why when I look at this and our regulation says that, you know, the letter has to state that it meets the parking requirement. And your parking requirements would, based on their zoning use, would, you know, be X number of parking spaces. I don't know what their requirement is here.
Well, they asked the same question if, excuse me, if any public would be coming there. And when we told them that there's no public coming there other than just us going in the mornings, or, you know, the parking lot is large enough to park probably 10 cars. But there's not gonna be any of the general public coming there for any reason. And anything that's on that building, if you see the way the building is, inside the building, if you come to pick up a remains, you would back inside the building. Nothing would be going in and out as far as being seen in the parking lot.
In the past, we've asked for and received that particular wording. I'm gonna make a recommendation that this be approved if it meets all the requirements. Mr. Gribble, does he meet all the requirements except for that one issue that I've got?
Yes, sir.
I'm gonna make a recommendation that it be approved, subject to picking up something from the zoning about the parking. Because that's an issue that we've had before, and that's an issue that comes up quite often. But it is in the regulations that one particular thing has to be answered. The water and sewer you did good on, your zoning use you did good on. It just does not state that the parking is met. That's the only thing. So if you'll go back to the zoning board, I don't think you'll have a problem getting that. But if you do, you might let Mr. Gribble know, and then maybe we can,
Well,
I can pull it up on the email.
I don't know that we'll have a trouble getting it. Now, on the water and sewer, if you will notice, or Mr. Gribble, I'm sure saw it, we had to end up giving a copy of the water bill that stated its own sewer.
Yeah.
Because the people at codes, when I kept going back and saying, you put that water and sewer is available, then I go back and I said, the state requires that it says it is on sewer, not that it's available, even though this building has been on sewer for 30 years probably. They refused to give me a letter stating that it's on sewer. He said, I'm not changing the letter.
I can understand that because of the age of the building and stuff. That, and the zoning office would not necessarily answer and write you a letter stating that. I would never sign it. The water and sewer department that maintains the water and sewer for that property would be the individuals that would have to do that.
So that's where I went.
Yeah,
to
so you
water
went
and
to the
sewer.
water department and got that.
But the only thing, the letter from the water and sewer department stated that water and sewer was available, even though this building is that old, and in that area, that industrial area,
Sections,
water and sewer's been there for,
I mean, what section
For
of
a long
parking
time.
requirements under? Rules, yeah.
I ask a question about signage. Are you required to have any signage on the exterior of the building? I mean, that's, I've never heard of that being specifically required, but I just wondered if you planned any signage.
When you find it, Mr. Gribble, would you please read it for the board?
It's Rule 0660-6-.01. It says each person desiring to obtain an establishment application shall submit to the board, and it lists several things, but the part that Mr. Hinkle is talking about is parking space availability required for the location, or a statement indicating that the zoning authority has no requirement with respect to parking.
That's a regulation. Yeah.
Yeah. They set us up on
Withdraw
an
my
email
motion.
thing with all these letters, so I can just go back and get that.
Pardon?
They had set us up where they emailed us as the letters were approved, so I'll just go back and find that from that gentleman. Okay.
Seconded.
Okay, now, are we making, your second, my motion
Correct.
to approve it, subject to
Fax the letter back in.
the letter back to Mr. Gribble?
That's correct.
Okay. And that's based on the regulations? Okay.
I have a motion from Mr. Hinkle, a second from Mr. Neal. All in favor?
Aye.
Any opposed? Motion carries. Our
Good
next-
luck.
Mr. President, Mr. Britt's back in the room now, so Mr. Gary, this applicant is seeking licensure as a funeral director and embalmer by reciprocity, and the reason he is here today is for the board to determine whether 62-5-311B3 he meets those qualifications for licensure. Just go ahead and state your name and any opening statement you want to make, Mr. Britt.
Gary L. Britt, reside in Ringgold, Georgia. And I understand the question is regarding my test scores from the state of Georgia. And as I get older, I face a lot of different complications, and one of them is being that records kind of disappear after 30 years. The state of Georgia does not have test scores back on record at the date of my exams in 1976.
Mr. Britt, Georgia has certified to the board that you have a funeral director and embalmer's license that does not expire until March the 31st, 2016. The main question, I think, for the board to determine today is the part regarding five years prior. I think, if you will, tell the board a little bit about when you were licensed and what you did for your employment, and then when you came back to funeral service and how long you've been there and things of that nature.
I left the funeral industry in 1985, and when
Pick up a little bit, please.
I left the funeral industry in 1985 and went into aviation, and I'm at the end of my aviation career, and I want to be back in the funeral business. I live, like I say, on the Georgia-Tennessee border. The reason for my wanting the Tennessee license is to make myself more marketable in the area. I have been active again in the funeral business for the last year with the funeral home in Lafayette, Georgia, as a part-time employee. Prior to that, I have not been since 1985. I attended Gupton Jones, graduated in 1976, and became licensed. So,
Held that license ever since,
well, it went inactive, and I reactivated it.
but you still kept it up.
Yes, yes.
Have an inactive? Okay.
What did you do to become inactive? Did you just, how did you do that?
Goes inactive when you don't pay your dues and.
Just didn't pay them?
Correct.
Or did you tell them you wanted your license to be placed on an inactive status? And how long, for what period of time?
1985 until last year, early last year, 2013.
What's the requirement to reactivate them?
A reactivation fee, and that's another problem of getting older. Your memory's gone. I want to say it was in the neighborhood of $200 per license.
We have visited this problem before. I mean, situation, about 5 continuous years.
My situation was a Georgia person too.
All right.
You've been unlicensed for how many years?
1985 until 2013.
Paid a reactivation fee in Georgia.
Yes, sir.
And then you went to work, and you've only worked 1 year?
Yes, sir.
I thought we had a 5-year requirement.
Well, that's the reason he's before you today, Mr. Hinkle and board members. He was issued a license, according to Georgia, he was first issued a license July 31st, 1979. And from what he has told you today and what he has told us previously, he worked for 5 years at that time, but his 5 years has not been, and then he went out into aviation, into a different job, different profession, and did that for a number of years, and then he's been back at the funeral home part-time for the last year. So that's the reason that
You've been licensed in Georgia for 1 year.
My license was renewed, yes, ma'am, and reactivated.
I think in the cases that we have kind of overlooked the 5-year plan, the people had been in continuous license for that period, even though they had not worked at a funeral home. So this is a little different situation where the license was dropped, you know, as far as state law says you have to be licensed to reciprocate for the past 5 years. I do know the situations prior where we did, the person had been licensed in Texas, moved to Georgia, you know, but he had had the license all the time. He just hadn't worked in Georgia but 4 years, so to come and reciprocate to Tennessee. So, however, before he came to Georgia, he was licensed.
Right.
So,
One of the other requirements was I had to retest and do the laws and rules test in the state of Georgia. I have done that here.
Have done that?
Yes.
he's passed the Tennessee laws, rules, and regulations exam. The question is about the 5 years, so that's the reason he's before you today, and the reason that
But he could retake the funeral directors. He
have
can't
served
take-
he would
have
have
served an apprenticeship.
have served an apprenticeship in Tennessee if he was going to do it that way. He undoubtedly he meets the requirements for a funeral director's license because he has the education for that. So undoubtedly, I mean, I don't think that's was the question. The question is involving the embalmer's license, where we now require an associate's degree, and how for, I guess, since 2010, something like that, 8, 9, or 10, somewhere along in there, and he has a diploma from Mortuary College, and not an associate's degree. So then, since he doesn't have the associate's degree, then the question comes up about the 5 years. And he does have 5 years from 1979 to 1985, but he doesn't have 5 years immediately preceding his application to us here in Tennessee.
Legally, he is only eligible to accept the funeral directors in Tennessee and not the embalmers, is what you're telling us then. Well,
that determination is to be made by you, ladies and gentlemen. there's no question of what he meets the qualifications for the funeral director. The question is about the 5 years and embalmer part. And I don't know, legal may want to chime in any time, but before, it's my understanding that that's left to the interpretation of the board.
The requirement says that a non-resident applicant has been licensed by another state or provincial authority in good standing for 5 years and has been employed as a funeral director or embalmer or both for such time. The law doesn't specify whether that needs to be immediately, whether it could have been 30 years ago.
Oh, it's, okay, so it doesn't say for the past, see, we've been kind of going under the assumption it said the past 5 years, but it doesn't say that, it just says for a period of 5 years.
Unless it's, I mean, this is the 2010 book, unless it's been. I mean, I feel like that would be left to the interpretation of the board. It would seem to maybe imply that it would have to be recent, but it doesn't actually state that. So it'd be up to the board's interpretation, and how you've interpreted it in the past would be relevant as well.
Remember when we did the rules back in 2012, to begin with, there was a rule proposed to address this more specifically, and then it was taken out because at that time it was determined to leave the rule out would give the board the opportunity to interpret it on a case-by-case basis, being consistent with what the board had done in the past.
I second.
I have a motion for Mr. Patterson, second for Mr. Hinkle to accept. All in favor?
Now, this is for his funeral license and embalmers, correct?
All in favor?
Aye.
Any opposed? Motion carries. Congratulations.
Put him to work.
All right, I think the next is Department Legislation Proposal for 215 by Attorney Ellery Richardson.
Our department is soliciting the different boards to see if there's any proposed legislation they think they would want to propose for the department to submit. And the only thing I have, Mr. Gribble and I had talked about, is just deleting some superfluous language about preservation of exam tests, which, since we contract with an outside company, we don't have them anyway. So nothing really substantive there. And so I wanted to present to the board to see if they had any other suggestions about clarifications or proposed legislation.
In the department proposed legislation, or does that have to come?
The process, the way it works, if the board had a piece of legislation they wanted to propose, then in working through Ms. Richardson, then that would be prepared and submitted to the Assistant Commissioner for Regulatory Boards and to the Legislative Director for the department. And eventually all those submissions get reviewed and pared down to a smaller number, and then the commissioner recommends to the governor's office to make those as part of the governor's packet, is the way it's referred to. And then that's presented to the legislature as part of the governor's proposed legislation. So, you know, it would be, if the board has something, it would be good to relate that to Ms. Richardson as far as it being a guarantee that it would wind up as being proposed legislation. That's no guarantee.
When does this have to be in? Yesterday.
Well, I was supposed to give my initial draft back June 30th, but since the legislative session isn't until next year, I'm sure if the board found something this month or next month, I can see if I can get that put in. 'Cause I'm not sure when the final deadline is, but I thought I would bring it up because I believe we have some time.
No, the one thing that we struggle with a lot and it's just like the establishment that we just approved. I wish we could, we've talked about this before. That's an establishment, but it's not a funeral home. It's not a funeral home. They're actually doing pickup and delivery, and if I'm speaking out of turn, let me know, because I don't want to get us in trouble. But the bottom line is we have these come up all the time in front of us. And they're storefronts, they're warehouse buildings, they're every kind of thing that they can move into. When they leave here, they meet the requirements. They got the same establishment license that the people that are in the funeral business, And it's almost like, and I know we had this issue many, many years ago about the casket stores, and we've had this about what can be sold in certain places, what can be brought in and all that stuff. But to me, I wish there was some way that we had a license system that would, a person, if I wanted to do pickup and embalming only for funeral homes, that I could do that under another set of license instead of me having a license, because when you think about it, that license is for an establishment, okay? Now, there's nothing to keep me till the inspectors catch me, and our inspectors do a great job of going up and taking a building, coming in here and telling y'all I'm gonna do this. Next thing you know, I got people stacked in there and I'm having funeral services in it. See, this is something that once we get that license, if they decide to have funeral services in it, they've got an establishment license.
So you would suggest a sort of limited license for
I don't know
services
what
like that where the public
Y'all are in
wouldn't-
this business. Help me with this. Try to explain. Y'all are in the funeral business.
Well, I've
Y'all-
always been. To me, a crematory ought not to have a funeral establishment license, but that's the way it is.
Yeah.
So theoretically, a crematory can handle funerals. It's got a licensed funeral director. So I think there's degrees. A funeral home is a funeral home, A mortuary service shouldn't necessarily be a funeral home. It should be, now, it might be a subtitle, but under a mortuary license, you can do this, this, and this. Funeral home, you can do all this, So it's, I think, always been a problem. I guess you could go on and on and on. However, there's about 3 or 4 major areas: funeral home, mortuary service, crematory. But see, a crematory has an establishment license, so they're theoretically a licensed funeral home and can do anything anybody else can do, because you have to have a funeral director, manager. So, but those are things that have, I think a lot of states, they're different license for the different entities, I think they all still need to come under the board's regulation because they're funeral related, but those are some things you might kind of think about, Now, Mr. Gribble, does that pose a problem when you do separate them like that, or is there reasons that or just never has?
Never has been done. I mean, I don't see any problem it would pose. It would focus on what type business you're operating and what you have a license for. I think it was considered one time, I think the association, maybe many years ago, considered that, and may went as far as to have a bill introduced at that time. But that would be the that would be what you're saying is different types, one for a mortuary service, one for a funeral home, and one for a crematory.
In other words, a crematory license would be regulated, but it would not be a funeral establishment license that it has now. a mortuary service has a funeral establishment license. It would be a mortuary service license, you know, where they could do what they do, but they could not necessarily, you know.
Only be a graduated
Right.
type situation.
But just like I asked him.
You know, that,
I don't know how you do it.
I thought at one time there were some issues that we talked about and never did do anything on. But if it, you know, it just, to me, it just seems like there should be, and I'm gonna say this, and a licensed contractor, he has to have a plumber's license, or he can't even plumb. Even though he's got a contractor's license, he still has to have a plumbing license.
Yeah.
Electrician has to have, even though he's working in the same industry, he has to have electrical license. You know, in this industry, you know, we have people that build establishments that are nice funeral homes, and then we have people that leave here with a license as a licensed funeral home in a Quonset hut. And that's exactly what we just did. That's a Quonset hut.
I guess the next step would be the board.
It's
Oh, sorry.
It's a Quonset hut.
If the board would like to go forward with a proposal on limited licenses.
Here in the license.
Hearing, yeah, some kind of
Like a
hearing.
tiering program for the license. If the board approved that, I would submit it to.
We've got to have a work session.
Actually, not entirely sure how it would happen. This is my first year with legislative proposals.
You find out for us.
Has this been visited in the past, Rob?
Not recently.
Tiering.
I think it's been
Bob,
visited in the
Mr.
past.
Batson, the director of the Tennessee
Well,
Funeral
look,
Directors
sitting back there.
Association is here. In your time with TFDA, has this been visited?
Been visited a few times, yes. It's a tiered license. David Dryden's on a tiered license, and it's just a graduated license.
What's the feeling across the state?
It varies. That's one of the reasons it didn't.
Well, a storefront, even though it doesn't have the full facility, basically, some of it is, you know, even though they're handling, it's a little different than a crematory or a, you know, criteria more so than like a crematory building or an embalming service building, parking, what have you. So, but I can.
Oh, I like a challenge.
You got one with this one.
If this board, with y'all's help,
Oh, we'd be glad to. We've been trying to find a way to do it, like I said, since the early 2000s.
ain't do nothing but get shot down.
Do you know any
But
other
you-
states that have the tiered license, or have you looked at them, any of them?
I don't know of any states that have the tiered license like we do. I think, or we.
Okay.
But it didn't come
And
out
that's
the way
a
they
good
thought it was
thing.
going to be, though, did it?
No, it didn't, but it did come out of that. That's
Right.
what
Well,
happened
and
there.
these people here this morning they go one step beyond because they provide embalming. But, from the pictures, they can't do anything in there but that. There's no facility for anything else. That I do not consider a storefront. Because
They
if
left
these
here with a
people are,
license.
well, I said, but that facility,
Yeah.
I don't consider it a store, what I consider a storefront. Storefront where somebody's got a desk and a telephone and they solicit to do and all of it. If these people are honorable, and I think we believe that they were, then they're gonna provide removal and delivery and preparation of the body if they're asked to do that. But, I do not consider them a storefront.
There was
That's in my mind, but they're issued an establishment license.
there were issues with disclosures about what each
Right.
more public, things like that. So, I mean, it gets really complicated.
Bob, where did this fall apart when it was done before?
The first time it fell apart, the consumer groups got it.
I can see where it'd be opening a can of worms. I mean, it would
Oh,
just, it'd go nuts.
Yeah.
I think where the issue lies in Tennessee, all these things come under and our establishment. In other states, a crematory doesn't come under, it's not a funeral establishment license. It has some kind of license, but it's not a establishment license to conduct funerals. And, maybe an embalming service has some kind of license, but it doesn't, it still falls under regulations from the board, I think, but it's not issued a license to be a funeral home. It's issued a mortuary service license. So I think it's kind of, the states that don't have problems it's never been a funeral home to start with. It's just been a mortuary service. It's just been a crematory. They cannot handle funerals, They can only do what's said. But our license so encompassing, everything's a funeral home. So.
On that note,
The good thing, if we do this tiered, in theory, you would lessen the requirements for them in these lesser tiered, and we don't necessarily want that, I wouldn't think. I mean, we with our stringent establishment license regulations, we kind of filter out some of that. some of the undesirables, I would think. Make it a
Not
little more
much.
difficult. Well, they still have to jump through a few more hoops.
Yeah,
but,
not much.
Well, you can see in just 10 minutes.
Yeah, right.
It's going off in different directions already. And
Yeah.
everybody's on the same page. They want the same result. It's just how to get there.
Thank you. So that's something we can be thinking about and talking to Ms. Richardson in the next month or so. And, but you kind of have a consensus what you could look into some things there too, see what we have to do to start the process.
If the board decides to do this, it will be a very long and involved process.
Right, yeah.
And there's no guarantee anything will get passed, or I'm not even sure how the process works, but I'll figure it out.
Probably, Mr. President, if it's okay, is for Ms. Richardson to submit the general ideal, is that the board discussed it, and this is the consensus of the general broad ideal. And then if it looks like it's gaining any momentum or steam within the department, then like someone mentioned, I don't remember who that was, work sessions maybe and things of meetings with different associations and licensees and maybe even consumer groups and all those things would be, in reality, it's probably not something that could all come together and happen by December of this year.
Oh, no. No.
But it might could somewhere later down the road.
I will present our discussion.
Do we have any new business to come before the board?
We're going to have a past president's luncheon.
Not for the next, well, I'll let Mr. Gribble address that because we talked about it yesterday.
Oh, I'm
and-
sorry, I didn't know y'all had already discussed it.
We've been in communication with Mr. Highsmith, and Mr. Highsmith has an employee who is his backup when he is gone, and that person had requested vacation for the second week of July, the second week of August, and the second week of September, which are the same weeks that the board meets. So I asked Mr. Highsmith, I said, what about October? He said, well, that's when the national convention is. So some of the people, that could be good or bad, people like Mr. Batson, who normally comes, probably will be engaged in other matters that time and won't be able to come. But then you might have some people that would be coming to the national convention that would also come to the luncheon to honor Mr. Highsmith. But I guess the short answer is it looks like it's going to have to be delayed for a longer period of time. And hindsight's 2020. Had we known all this, we would try to have done it in January, February, soon after he went out. But we didn't. We normally wait till April or May, and then he was involved in some mission trips and other things like that. And of course, we didn't meet in June, so it won't be for July, August, and September.
And changing the meeting date from one Tuesday to the next Tuesday is not really a good idea. Our calendar set up, just like we adopted the calendar so they know. So, well.
And our litigating attorneys, two of them are here today, and they're planning on setting some cases for you to hear. So they we're almost in the availability of rooms. We were able to change the May meeting, move it up a week. That worked out without any problem, but that doesn't always work out like that.
Well, I guess you and him meet together when we honor you.
Maybe.
Motion to adjourn.
With no further new business, do I have a motion to adjourn?
Motion we adjourn.
I have a motion for Mr. Neal, second from Mr. Patterson. All in favor?
Aye.
Meeting is adjourned.
Oh.